Today, we're going to be talking about Marbury v. Madison, the court case that established judicial review. First, let's define judicial review. Judicial review is the power of the Supreme Court to strike down any law it deems unconstitutional. Basically, the Supreme Court can determine whether or not a law is compatible with the Constitution. To illustrate this concept, imagine two transparent pieces of paper, one with the Constitution written on it and the other with the law in question written on it. Now imagine placing those two pieces of paper on top of each other. If they don't match up, the law is declared unconstitutional. This is a very simplified illustration, but the concept is the same. Since the Constitution is the supreme law of the land, it supersedes any law passed by Congress or the states. Thus, if a law goes against the principles of the Constitution, that law will be struck down. However, although the founders may have intended for the Supreme Court to have this power, judicial review is not explicitly written anywhere in the Constitution. Instead, it was established as a result of the court case Marbury v. Madison. Alright, this court case can get pretty confusing, so keep your hands, arms, feet, and legs inside the vehicle at all times. Before the election of 1800, Adams was president and Marshall was Secretary of State. After the presidential election, Jefferson became president and Madison became Secretary of State. Okay, that's all well and good, but the issue was that the previous administration had some unfinished business with the judicial branch. Literally. Adams belonged to the Federalist Party, so he wanted to appoint as many Federalist judges as he could before he left office. As Secretary of State, Marshall was responsible for delivering all of those judicial appointments. By hand. Now, this was back in the day when people got around using horse-drawn carriages, and there were a lot of appointments, so it's understandable that Marshall didn't get them all delivered in time. But the fact of the matter was, he didn't. And someone who happened to be named Marbury wasn't too happy about that. Marbury was a Federalist who was supposed to have received his judicial appointment from Marshall before the next administration took office, but that didn't happen. Now, Madison was Secretary of State, so it was his responsibility to deliver the remaining judicial appointments. However, Madison and Jefferson were Democratic Republicans, not Federalists, so they weren't too keen on appointing judges from the opposite party. Madison decided not to deliver the rest of the appointments. Understandably, Marbury sued Madison and requested a writ of mandamus, which is just a fancy way of saying that he wanted the court to force Madison to give him his judicial appointment. Now, because Congress had passed a law in 1789 stating that cases involving writs of mandamus would go directly to the Supreme Court, Marbury and Madison found themselves face-to-face with the Supreme Court justices. The awkward thing was, remember Marshall, the guy who couldn't deliver all of the appointments in time? He was now the Chief Justice of the Supreme Court. Yeah. So, in the plot twist of the century, Marshall found himself in the position of deciding whether or not Madison should be forced to deliver the appointment that he himself had failed to deliver. Should Marshall have recused himself from the case? Probably, but he chose not to. Historians speculate that this was because he saw an opportunity to expand the power and influence of the court. Whatever the reason, Marshall took the case, and he now had a difficult decision to make. If he chose to side with Marbury, and then Jefferson told Madison to ignore the ruling, the Supreme Court would be weakened because future presidents could simply ignore court decisions. On the other hand, if he chose to side with Madison, it would look like the Supreme Court was deferring to Jefferson, creating the precedent for the Supreme Court to bow to the executive in the future. Neither of those options was sounding all that good. So, he decided to establish judicial review instead. Marshall ruled that the law Congress had passed in 1789, which sent cases involving writs of mandamus directly to the Supreme Court, was unconstitutional because it didn't align with what the Constitution says about writs of mandamus. Thus, the Supreme Court shouldn't even be hearing this case. Unfortunately for Marbury, this ruling meant that he was not given his appointment, seeing as the case was dismissed. But judicial review was established. All right, that's everything you need to know about Marbury v. Madison. Thanks for watching, and I'll see you guys next time.